Chairwoman Abrams, Ranking Member Brown, and members of the House Criminal Justice Committee. I thank you for the opportunity to offer sponsored testimony on House Bill 245. The purpose of this bill is to update the weak and outdated obscenity laws in our state. Last updated in 2004, these laws were targeted at individuals who produce, publish, advertise, or exhibit obscene content and performances to juveniles. While these activities were rightly criminalized, the criminal codes do not address an increasingly common form of obscenity: those who willfully engage in an obscene performance in front of a child. House Bill 245 seeks to close this gap in our obscenity laws and relegate performances considered obscene or harmful to children to adult-only establishments known as adult cabarets. When I began my research on this topic, I was astonished to discover that there is no requirement in the law that limits obscene performances to adult-only establishments. Restricting performances considered obscene and harmful to children to adult cabarets, where the proprietor has a legal obligation to prevent minors from entering, is a simple and effective way of preserving the free speech rights of the performers while also protecting minors from exposure to obscene conduct. Increasingly, we have seen examples of children spectating and even participating in overtly sexualized performances. This state, both through the laws and established precedent, have always protected the rights of children to be free from exposure to obscene acts by adults. Now, with the indecencies of such public performances increasing, it is incumbent upon us to update our obscenity laws to reflect our continued commitment to this area. I thank you for the opportunity to give sponsored testimony, and I'm open to answer any questions.
Thank you both for your testimony. Members, do you have any questions? Representative Seitz.
Thank you, Madam Chair, and thanks to the two of you for this bill. Just to underscore what I think I heard you say, this bill in no way changes the current definition of obscenity under Ohio law, and neither does it change in any way the current definition of material harmful to juveniles. Rather, it simply applies those standards and the community standards of the court system to obscene public performances, whether by trans people or anybody else. Is that right?
Through Chair Abrams to Representative Seitz, that's entirely correct. So we rely on two definitions that are found in 2907.01, which are obscenity, what is obscene, and harmful to juveniles. Those are both based on the Miller test, which establishes the difference between legitimate artistic expression and free speech and what has been classified as obscene. We've been able to legislate obscenity for decades here. And what I noticed in my role as vice chair, when I tried to look at every criminal statute that's on the books and looking at current case law, what I noticed is there's a small gap that applies to the performers. So as of right now, I cannot, if I was the owner of a strip club in the state of Ohio, I cannot allow a juvenile to come into my establishment or I face criminal liability. But there is nothing stopping me from taking my performers out into the parking lot and having them perform in public. Currently, under Ohio law, public indecency doesn't apply so long as their bottom genitalia is covered, so they can be topless in public, and it doesn't apply, and children can be present, and there's no law that prevents that whatsoever in the state of Ohio. So we looking at all of these adult performers and saying we're going to modernize these laws and require any adult-themed type of performance where the conduct rises to the level of obscenity or what is harmful to juveniles to be housed indoors where adults only are present. And I think that's a reasonable bill and reasonable legislation for Ohio.
Follow-up. Ranking Member Brown.
Thank you, Chair. Thank you for your testimony. The bill defines adult cabaret performance in lines 62 through 72 to mean a performance in a location other than an adult cabaret that is, quote, harmful to juveniles, quote, or, quote, obscene, quote, and that features, among other performers, entertainers who exhibit a gender identity different from the performers or entertainers' gender assigned at birth, using makeup, prosthetics, etc., other physical markers, and who provide entertainment that appeals to a prurient interest. Is the phrase prurient interest defined in this bill or in any other section of the code that you're aware of?
Through the chairwoman to Representative Brown, no, it's not. Prurient interest, as what's been adopted into the Miller test, it's been outlined by Supreme Court precedent on what it is. Essentially, it's appealing to an overt sexualization or a sexualized thought, essentially. So it's conduct that appeals to a sexual interest. So you have the Miller test, and the reason that was included in this bill was to say not only do we want it to be obscene, but we also want to apply the prurient interest test as well. We want to create a high standard for prosecution under this bill, as high as I can get, using the standards that the United States Supreme Court has laid out for us.
Follow-up, Chair.
Follow-up.
Thank you. Now, it also uses the phrase harmful to juveniles, which is defined in the statute at 120 or 172, 173. They have the same meaning as in Revised Code 2907.01, where it is defined in some detail to include the material performance when considered as a whole appeals to the prurient interest of juveniles in sex, and the material or performance is patently offensive to prevailing standards in the adult community as a whole with respect to what is suitable for juveniles, and the material performance when considered as a whole lacks serious literary, artistic, political, and scientific value for juveniles. And then the word juvenile is also defined in 2907.01I as an unmarried person under 18. So the Ohio law and the bill defines harmful to juveniles to apply to anyone unmarried under 18 from 1 year to 17 years old, correct?
Correct. Through the chairwoman to the representative, correct. That applies to any minor.
Follow-up, Chair.
Follow-up.
Thank you, Chair. And what appeals to the prurient interest of a 6 or 7-year-old, I assume you would agree, would be different than what appeals to the prurient interest of a 16 or 17-year-old, correct?
May I?
Yes.
Through the chairwoman to the representative, it's not about the prurient interest as to the age of the child. It's to the prurient interest as based on community standards uniformity. That's the Miller test. That's what that portion stands for. So the reason that harmful to juveniles is separate from what is known as obscene is that we could prosecute those separately. And that's why in our bill, the penalty phase prosecutes those and applies penalties differently to whether it's obscene or harmful to juveniles.
Follow-up.
Follow-up.
Thank you, Chair. I agree with you with regard to the penalty phase. There is a distinction made, but in the rest of the bill, it just uses the word harmful to juveniles, the phrase, and the word juvenile, which means anyone from basically 0 to 17 unmarried. So it applies to, without regard to age, to juveniles. Wouldn't it therefore fail to provide fair notice to an entertainer as to what is in fact prohibited if there is such a wide variety in the age of the juvenile to whom the entertainment is being provided?
Through the chairwoman to the representative, that answer is no. It will provide them with very strict notice that the standard that's being applied is the Miller test, which is community standards. It's been defined on what it is. The prurient interest isn't determined by the age, sex, gender, mental capacity of an individual. It's based on community standards across the board. And what community decides is appealing to a sexualized interest. And these are the same standards that every single performer in the state of Ohio has had to abide by before this bill has been put into place. The difference is we already assumed that like strip clubs were going to be obscene, so we created this environment where it had to be adult only. But the only people that could be punished through our statutory structure was the owner who allowed a juvenile to come in. The actual juvenile could be punished, or any person that was trying to get the juvenile in by pretending that they were 18. Those are the laws that I have here in my possession I could show you. In addition, there's other statutes that say if I go inside and I tape the performance of a stripper and take it outside and show it to a juvenile, that's dissemination, that's unlawful. But there's no bill that says it depends on the age of the child whether or not it's criminal to expose them to obscenity based on if they're 1 or 17. It says it's illegal to expose them to obscenity, period. Those are all of the statutes that we have in the state of Ohio when it comes to dissemination, pandering, right? No, even if you're a parent, you cannot show pornography to a child. It doesn't matter if they're 18 months or 17 years old. Under the current laws, you're not supposed to show pornography to children because it's obscene in nature. All we're saying is the same standard is going to be held to performers that are engaging in adult conduct that rises to the level of obscenity.
One more follow-up, yes.
I appreciate the chair's indulgence. Thank you. I'm aware of several U.S. District Court cases which have reviewed laws which I believe are very similar to H.Bill 245, House Bill 245. And these cases, these district courts have held that those laws were unconstitutional in various ways, including containing unconstitutional content-based restrictions, unconstitutional viewpoint-based restrictions, unconstitutional because they're overly vague and overbroad. And these cases I'm referring to come from very red states, including Texas, Tennessee, Montana. Are you familiar, Rep. Williams, with those cases? And if so, how do they differ in your mind from the legislation that is before us today?
Through the chairwoman to Ranking Member Brown, I am familiar with each one of those cases, and they differ substantially from the bill that we introduced. So when we looked at drafting this bill, we knew those cases were pending. Some of them have been settled since then on unconstitutional grounds, and most of them were based on the premise that certain types of performances were automatically obscene. And that's where the viewpoint discrimination came into play, because you had to look at the type of performance and automatically assign it obscenity. We're not basing it off of any type of performance. We're saying that this category, these categories of performances, only if they rise to the level of obscenity does it then become illegal. So it's not based on, it's based on the conduct of the performer. So when we start talking about what is obscene in the state of Ohio, we're talking about things like simulated masturbation, full-born nudity, right? These type of conduct, that shouldn't be done in the presence of a minor. The question becomes, why do we believe that obscenity should be allowed in the presence of a minor? When for decades we've said across the board we shouldn't be doing that in the presence of children because we're going to sexualize them. Now, because we include a bill that expands the definition to a certain type of performer that doesn't like that, now all of a sudden we're supposed to remove all these prohibitions from the books in the state of Ohio, and the answer is no. We're going to be held to the same standard we've been held for decades, which is adults who want to engage in adult activity do so in adult environments where children are not present. If you want to engage in adult activities, make sure kids are not around. And if you're a performer, you're going to be held liable in the state of Ohio if kids are around while you're engaging in obscenities like simulated masturbation.
Thank you for your testimony. Any other questions? All right, that will conclude the first hearing of House Bill 245.